Alan, revenue ruling 2023-02. I can't get a basis step up anymore on assets in a grant or trust. Can you explain that succinctly in English and then tell me anything you want to say about it?
Okay, so I establish a trust. It's irrevocable. It's for my descendants. And when I set it up, I put $1 million in it, and I retain the right to replace trust assets with assets of equal value, which causes the trust to be disregarded for income tax purposes. And as a result of that, the income of the trust goes on my income tax return. I pay the tax on that. It's not considered to be a gift to the trust, and it's a lovely, lovely way to do estate tax planning. And in addition, under a revenue ruling from 1985 called Revenue Ruling 85-13, I can sell assets to that trust. And because the trust is disregarded, there's no income tax when I sell assets to the trust. It can pay me a low interest note, so those assets can grow at 8 and 9% and generate income, while it owes me a note at 4%, and the arbitrage is a big difference. And then when I die, if the trust is disregarded, do the assets in the trust get a new income tax basis? And there's two schools of thought on that. One school of thought is, hey, the trust is disregarded. The Internal Revenue Code says if I die, any bequest I make, the asset gets a stepped up value. Well, I die, the trust is disregarded. Did I make the bequest or did the trust make the bequest? Do I get a step up or not? The IRS has really been silent on this for decades. This goes back to the 1980s, 1970s. They've never said much about it. There was one private letter ruling where they gave a step up, but it might have been a mistake. But
I think it was in the foreign context.
Yeah, it was a foreign one. So Senator Sanders and others,
Elizabeth
Warren, have been sending letters to Secretary Yellen saying, Yellen, and she was, what are you going to do about this? What are you going to do about this? Well, the IRS issues Revenue Ruling 2023-2 and says, sorry, Charlie, no step up. Well, the fact is, now we know that the IRS's position is that there's no step up, but the IRS doesn't have the authority to change the law here. So in my humble opinion, maybe not so humble and not well respected opinion, there's just as good a chance that you'll get a step up when this finally goes to an appellate court as that you won't get a step up. But it is dicier now that the IRS has come out and that you would have to disclose on your tax return, I'm taking a position contrary to the IRS's position. What are your thoughts, Marty?
Well, it clearly puts the IRS on notice. It's like waving a red flag with shiny bright lights flashing on it. I don't know that I would say that there's just as good of a chance of a court respecting the step up in this position or not. I know that there are practitioners that have taken this position, a meaningful number of them. I know that there's a meaningful number of practitioners that have consistently said this doesn't work and it's not an appropriate position to take. So I'm not going to say that anyone's right or wrong because I don't like to set any standards. I don't want to have a recorded webinar that I do be used as evidence against somebody. So I'm going to just say that you have to proceed with caution, which is obvious because the IRS has said it doesn't work. Whether you've done it before or not done it before or want to consider it now, you need to talk to your tax advisor. Clearly, the risk of such a position is increased because the IRS has now in black and white said it doesn't work. But again, this is one of the many, loopholes that some have identified that need to be changed to prevent what is viewed by some as unfair advantage to wealthy people trying to plan their estates and their income taxes. So it's